Hey, welcome everybody to the second Law of Self-Defense show for Monday, July 25th. Come on in, make yourselves comfortable. Sorry for being a couple minutes late. Steve, I can't remember. Steve, were you going to join me for this one or not? You know what? I'll send you the, I see you're in the comments. I'll send you the invitation. Hold one. I'll send it to your presidential email address. You'll know which one that is. All right. For those who don't know, I am Attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you as always. Thank you very much. Welcome aboard. Welcome aboard. We should have an interesting show for you today. It's not really involving a self-defense case, but it involves a procedural question that I thought, and here's Steve, that I thought you all would find interesting. And that is the question of whether or not a defendant can fire their lawyer. Now, you would think that would be an automatic yes. But as it happens, it's not. There's a lot of confounding factors here. A lot of confounding factors with whether a lawyer can fire their client as well. But we have a case out of Montana that has some interesting kind of procedural steps on this question that I think would be helpful. And the decision happens to be, lo and behold, who knew that appellate courts could do this? The Montana Supreme Court wrote a decision that's largely in English, so it's easy to understand. So this will be a good example of a decision that we can all step through collectively. It's not all legalese. It's relatively short, and it illustrates this question of whether or not a client can or cannot fire their lawyer if they want to. So let me just make sure I have that decision ready to go. For those of you who are Law Self-Defense members, this should be streaming on your dashboard. As always, you will get priority for getting your questions answered, assuming that's working. We have had a couple little glitches. And just before I bring Steve on, I'll mention that the sponsor of today's show here at Law of Self-Defense is none other than Law of Self-Defense itself and our Hard to Convict webinars. These are 100% free webinars that inform you on how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. They don't cost a penny, but there are limited seats for each one. We run it a couple of times a week. If you'd like a seat in one of those, just have to go to hardtoconvict.com, hardtoconvict.com, grab your seat, enjoy the webinar. Again, it doesn't cost a penny, and I hope you enjoy it. All right, so let me close that down. Let me bring Steve on board. Hey, Steve.
Hello.
All right.
Can you hear me?
Yeah, we hear you great. Great
Excellent.
audio.
Hey,
Steve
I got my new microphone.
Yeah, upgraded his AV equipment. That's awesome. It's not 1980 anymore, folks. We're in the internet age now. That's great. Your lighting's great too.
Oh, thank you.
Good work. Good work. All right. So for those who don't know, Steve, give us a 1 or 2 sentence summary of who you are, what you do, just so people have context.
Yes, I'm a practicing appellate lawyer in Florida in the 5th District. I practice in the 5th District for the Public Defender's Office. So all of my clients, if I'm your lawyer, you're in big trouble.
Okay. Folks, we will be taking questions throughout the show. I probably will answer them at the end unless I see something juicy in the interim, but they do need to be super chat questions. That's the only way we can effectively and efficiently work through those, because otherwise we get hundreds of, there's hundreds of comments in the chats. It's impossible for us to read through those. Also, if you're looking at this on YouTube and you see a big red subscribe button, you're doing it wrong. All right. You got to pound that subscribe button until it turns gray. It doesn't cost you a penny, folks. And the more subscribers we get, the more leverage we have on YouTube, the broader we can get our content distributed on that platform. The same, by the way, with the likes. So we have 130 people watching right now. We'll have a multiple of that within a few minutes, but there's only 45 of you who've hit the like thumbs up button. Folks, presumably you're here watching the show because you like it. Hit that like thumbs up button. That's a big help. And please put something in the comments, even if it's just your city and state, because that also helps to fool the YouTube algorithm, which, as you might imagine, is not by default favorably disposed to anything we do over here at Law.
I think it's fun to see where everybody's from too, and you have a great chat group, by the way. I think your comment section and your chat group are a very educated group, an interesting collection of people and from different walks of life. So I used to be a troller, or what not a troller, a lurker, until drawn from the comments section onto your wonderful show. So good folks you have in the comments, generally, not all, generally.
Well, we're very lucky to have you here, Steve. So as Steve said, he does appellate court work, and Steve has spent many years as both a prosecutor and a public defender doing real go-to-court law. As all of you know, my real legal practice is legal consulting. So Steve has a lot more insight into many of these nuts and bolts than I would be able to bring to the table. But with that, let me pull up the case I wanted to talk about. This is out of Montana. I believe it was sent to me by my buddy Will Parker up there. I see Will's in the comments as Freddie Merck. Will's a great firearms instructor up there. If you're in the at least, well, I guess anywhere in the region, distance is very relative. So what's a long distance here is a short distance up in the Montana area. But he's up almost in Canada. He's in the Kalispell area of Montana, up there by Glacier National Park. If you're looking for solid self-defense gun instruction in particular, I would strongly recommend you give Will a call. Will, feel free to drop your URL there in the comments. So the case we're looking at is State v. DeWise, or DeWise. I'm not sure how to pronounce it. Handed down just a few days ago, July 19th, 2022, by the Montana Supreme Court. I'll expand it as we step through it so it's a little bit easier to see. But before I do that, there is one idiosyncrasy of Montana that I think I should point out, and that is most states have a 3-tier court structure. I mean, for serious matters. So they have a trial court. I'm talking like for felony type things. They'll have the trial court. They'll have a mid-level appellate court, typically called the Court of Appeals, and then they'll have a state Supreme Court. So before an outcome from the trial court gets up to the state Supreme Court, it normally has to go through the mid-level Court of Appeals. There are exceptions, typically for things like capital cases. Often they're immediately appealable to a state Supreme Court. And of course, there are lower level courts that I don't bother considering, like municipal courts or traffic courts or water courts in some states, things along those lines. But for our purposes, especially use of force type events, we're talking trial court, mid-level appellate court, state Supreme Court. And you have to basically work yourself up that ladder. Montana does not have a mid-level appellate court. So any appeals from the trial court go right up to the state Supreme Court. And frankly, it's just a reflection of the population or lack of population in the state. They just, folks, when I look at, when I'm doing research on use of force appellate court decisions, I look at Montana and I might find like 20 from the last 100 years. You look at California, you'll find 800 from the last 3 months. It's just simply a function of population. But if you're wondering how we got so quickly in this decision from the trial court to the state Supreme Court, it's because there's no intervening mid-level appellate court to worry about in Montana. So this case involves a defendant, now a convict, DeWise, I'll call him DeWise, who shot and killed his estranged wife and shot and seriously wounded her housemate. Was convicted on both of those and was sentenced. By the way, folks, Montana is no joke when it comes to sentencing. So for both the killing, the murder, and the attempted murder, he was sentenced to 100 years each consecutively. And because he used a gun, there were 2 10-year gun sentencing enhancements for each served consecutively. So he's looking at 220 years in prison. I doubt he'll survive that to ever get out. You can understand his incentive for wanting to appeal those convictions. So let me see if I can make this a little bit bigger so it's easier to see.
And I would say that Florida would join Montana in its severity, especially on gun crime. And, they're very pro-gun rights until you get convicted using a gun, and then you're away for life. So just because a state is gun-friendly does not mean that it's gun-friendly for criminals or people who have been convicted of a crime. That's right. Different from criminals sometimes. And so that distinction, people think, well, I'm in Florida, that's a pro-gun state, but boy, don't lose a court case with a gun. Yeah,
I was having that conversation this past weekend because I was at a A pistol course. I mentioned this in this morning's live show. It was Modern Samurai Project is the name of the company. Scott Jedlinski was the instructor, very prominent, very successful instructor out there. And it was a class specifically on using pistols equipped with red dot sights. Great class, by the way. I highly recommend it to anybody. ModernSamuraiProject.com. I think his classes are sold out for like 2 or 3 years, but
Wow.
take a look at your area. He teaches like 75 a year, and it's hard to find space. I got in because of my prominence in the community. Really, is I cheated my way in. But if you can get in, I strongly encourage it. He does a very, very good job of teaching you how to use a pistol with a dot on it very, very effectively, and a great shooter. But I was having a conversation with somebody because I had a backpack that CCW Safe had given me. CCW Safe being one of the self-defense insurance companies out there, one that I favor. I recommend people consider them if they're looking for self-defense insurance. And I had been at a CCW Safe event, and they gave me this backpack, which I was using this weekend. And so people started asking me about various self-defense insurance programs. And of course, as usual, as I just said here, I strongly recommend people consider CCW Safe if they're looking for that kind of thing. But I always feel obliged to caution people that these policies, these plans, even the good ones, are not get out of jail free cards. They just pay your legal expenses. If you screwed it up, they'll pay your legal expenses as you get convicted and sentenced and go off to prison. They don't keep you from going to jail if you did it wrong. So all the more important, of course, then to make sure that you're doing it right. And by doing it right, I mean making sure that you're using force, if you are using it, well within the legal limits, which gives me an opportunity, of course, you all know me, the grift never ends, to mention my book, The Law of Self-Defense. This is a real physical book, folks. It's not just some kind of PDF download. Oh, there is. Steve's got his. You can get the book for free, folks. Now, if you want, you can go to Amazon. There's over 1,000 reviews of the book. It's solid 5-star rated. But Amazon will charge you $25 for the book and shipping and handling. I'll eat the $25 to get this book into your hands. I do ask that you cover the shipping and handling to get the cost of the book to you. But if you're willing to do that, I'll give you the book for free. And you can get this at lawofselfdefense.com/free book. And what the book teaches you is not legal tricks. It teaches you where the legal boundaries are so that you're informed enough to do it right if you are compelled to use force in defense of yourself, your family, or your property at lawofselfdefense.com/free book. Easy enough to remember.
Now, and it's interesting you bring up, I wanted to, before we get into this case, there is a distinction between private lawyer and a public defender who's appointed by the court. So that's a context here that we need to provide for this case.
Right.
And I'm in the public defender land, so I deal with this a lot.
And by the way, folks, I do have in fact, I'll change my little, my title here on the screen. Well, then you won't be able to see it if I change it. Maybe I'll do that later. But if you'd like to read this actual decision, you can find it under the defendant's name. So it would be lawofselfdefense.com/Dewise, DEWISE, and you'll pull it up on the screen just like you're looking at this right now. But if you're interested enough to want to make a bookmark of it or something so you can read it again later at your leisure, that's where you would find it. So it's easy to find. So here we have the opinion of the court. And by the way, here's a good opportunity to kind of step through for people what an appellate court decision looks like. So you have the parties in the case, the state of Montana versus Dewise, the defendant in this case. We have what's called a citation, which is kind of like a license plate number for this particular decision. These come in a lot of different forms. Don't worry about it too much. Just think of it as a unique identifier. And then kind of a summary in paragraphs, the state, the level of the court, and the year in which the decision came down. Then we have, typically they list the counsel, the lawyers involved, the judges involved, and then we get into the opinion. And normally the opinion's written by one of the justices, and then the others will just concur, maybe write a concurrence, dissent, maybe write a dissent. By the way, if they ever write a dissent, for God's sakes, read the dissent. The dissent's often one of the more interesting parts of the decision because it gives you the counter argument. If there's no dissent, you're really only hearing one side of the story. And while that is law, it's not as informative as if you have the opportunity to hear the argument from both sides. And then we get into, oh, sorry, go ahead, Steve.
Well, I was just going to say, this is my life. But if you're talking about reading appellate decisions, generally the way it's structured here is exactly the way. You'll have a summary, and then you'll have a factual and procedural background, just like here. And that's basically the facts of the case. And then there's going to be some sort of summary of law. So either that's statutory or case law that they're applying to this fact scenario to reason into a result. And then they'll compare the facts of your present case with the facts or the text of the law and integrate those things to come up with some result. So that's sort of the parts of an appellate opinion generally.
So they'll be looking to other case law where it's similar or where they can distinguish, where arguably it's the prior case law shouldn't apply because it's sufficiently different, blah, 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 that what they decided last time shouldn't apply this time. Did I lose? Uh-oh. My mouse is giving me a hard time.
I can hear you. Lost your mouse?
Yeah. Can you hear me?
I can hear you.
Okay. Yeah. My mouse is being temperamental. Okay.
Right. And source of law is kind of a question, because in a source of law question, you have the statute, which is the legislative pronouncement, but that's generally going to be broad and general, and it will apply to all everybody. And so taking that broad concept and applying it to specific facts sometimes is difficult. That's why case law is really helpful, because they'll take that statute, which is a general statement of law, and then give you examples. Here's where it applies, here what doesn't apply, and you'll kind of see where the edge is on that thing. So that's why case law is helpful to lawyers, to explain the statute in a more concrete, factual, example way.
And it's really how we're taught law. I mean, when we go to law school, we don't just read a bunch of statutes. In fact, that's less often the case than we're given cases to read, because when you have an actual case, you have the reasoning of the legal arguments that are being made.
Well, in fact, so much so that I think a major downfall of a lot of beginning lawyers is they go right to the cases and they forget to read the statute.
Right.
Yeah.
All right, so I'm going to start reciting what happened here in this case, largely from memory. I had to plug my mouse, and I guess it needs to be charged up. So, but we have here the defendant, now of course the convict, DeWeiss, and he was having difficulties in his marriage. So his wife decided to leave him. She went to move in with a friend of hers, and so now we have the estranged wife, the friend, and a third woman, all living together in this home. The defendant here, DeWeiss, was not happy with this arrangement. At least once he'd gone to the home and pounded on the door in the middle of the night. The other women were alarmed about his behavior. And at some point, one of the women came home to the house, went upstairs, and found the estranged wife dead and the second housemate badly wounded, both because of guns. So the estranged wife had been shot dead. The other housemate had been shot and severely wounded. And the investigation would trace this back to the husband. And the husband was ultimately charged with both intentional homicide and, there we go, I'm back. And so I probably have 1% battery in my mouse right now, folks. So this may be a little iffy. So he's charged with one count of essentially intentional homicide. I think they call it deliberate homicide in Montana. And then a second count of attempt. And then he used guns, so there's a couple of gun sentencing enhancement bonus awards on top of that. Now, it's not always the case, folks, but if it were like kind of a law school exam question, generally the penalty for attempt is the same as the penalty for the successfully completed crime. So you don't get a break because you failed in your attempt. Here we have attempted murder, we have actual murder, and we have attempted murder, and the sentence for both is 100 years each. That ultimately, as I mentioned earlier, he'd be sentenced to serve consecutively. It's kind of the norm that people are, when they have multiple sentences, it's concurrently. And you'd think with a 100-year sentence, it would hardly matter. And so when I see something like this, maybe Steve has some insight into this, it always makes me think that the judge just wanted to make a point. Obviously, you're not going to punish somebody twice as much with a 200-year sentence as you are with a 100-year sentence, but you are communicating something to the community, perhaps. What do you think, Steve?
Well, that's a good question. It's dependent on the judge. A consecutive sentence over 100 years seems kind of ridiculous, but what they're seeking to do is, usually you see it on multiple 5-year felonies. There are implications of that. Basically, like if you have jail credit, some people have 2 years in jail credit. That'll only apply to the first sentence if you have a consecutive sentence. But it's really up to the judge and the sentencing. They have the discretion to, because this is in Florida. Of course, I speak from Florida law. So it's almost random. I think that consecutive sentences get a little outrageous sometimes. I mean, that was the change, if you remember the aggravated assault case in Jacksonville, with a woman who fired multiple warning shots and was convicted, I think, of 3 or 4 or 6
Maurice
assaults.
Alexander.
And then, Marissa Alexander. And then she was sentenced consecutively by statute to multiple 15-year sentences to, I think, got a 60-year total sentence. And that resulted in a change of the law here regarding ag assault as applied to the 1020 life statute. So because in some things they try to really put you away forever. And that's kind of what, and like you say, at this point, it's a, triple life consecutive. It's pointless. We all die within a reasonable lifespan. So it's really more of a point, a showmanship on the part of the judge. And it might have some real effects in cases that are less than this. But in a case like this, it's just making a point.
Yeah, so that Maurice Alexander case in Florida was an interesting one because there's no question in my mind, having looked at really all the available evidence, that she was just a bad actor. But because she was a woman, and then she claimed that she fired those shots because of she was a victim of abuse, she became popularized in the media.
Well, I push
they
back a little
typically
bit on that.
characterized her
I
as
push back a little bit on that because I think that there is an issue of proportionality. And the fact is that the sentence that she was given was basically a life sentence, and that was disproportionate to the crime. Maybe it's the public defender in me, but it was a mistake to have the ag assault firearm within the 1020 life statute, as far as I'm concerned. And so even if she was a bad actor in the individual, the result of that was a good result, I think, for Florida.
Well, I think you're right. The ag assault, I mean, it could not be left in the statute, the sentencing statute, because it was being subject, in my view, to a lot of abuse by prosecutors.
Right.
Being applied to, because when you present a gun in self-defense, and a prosecutor could readily argue, well, that also checks all the boxes for aggravated assault with a firearm that you now have to justify as self-defense, and suddenly you're subject to, you're being threatened with multiple 15, 20-year sentences. Even if you never fired a shot with the gun. So in your mind, it was a defensive display, but you're looking at 60 or 80 years in prison. And if you had prosecutors with reasonable judgment, that wouldn't be a problem. But there were cases that, to the common person, to my eye, certainly looked like something at least close to self-defense, not an obvious criminal aggravated assault with a firearm, but they were treating it as if it was the most vicious example of aggravated assault with a firearm you could possibly imagine. Well, and if they're going to abuse that so much, well, then you have to take it out of their hands.
Well, and you are a enlightened, rational actor here, but let me tell you the real world result of such a statute. I was shocked because I prosecuted for 6 years before I became to the public defender's office. And I was shocked when I came over to the defense side, because I always thought law was about facts and about the law. And those were the things you argued about. But what it actually does is empowers the prosecutor to threaten you. So what the result becomes is, if you do X, Y, and Z, then I will threaten you with more prison time. So you're not talking about law and facts. You're just talking about how much can I extract from your skin in order to extract a plea from you, that so that I can resolve my case. So it becomes a battering ram for prosecutors to extract pleas from people. So
yeah, I certainly agree. Taking ag assault out of the 1020 life statute was definitely the right move, and very favorable to defenders for sure. In the case of Maurice Alexander, in my opinion, they could have charged her with attempted murder. I mean, the shot she fired at her husband hit the wall next to his head. So that looks, I mean, in the media, they always characterize it as she fired a shot into the air. Well, unless you're shooting the gun underwater, you're always firing a shot into the air. They were trying to create the impression like she fired into the ceiling. In fact, they would say she shot into the ceiling, which actually is true. But the bullet hit the ceiling of the next room after it passed through the wall next to her husband's head. I mean, it looked to me, having seen the crime scene photos, like a miss.
They're just saying like that she's a bad shot.
Yeah. And he was standing beside their 2 small children at the time. So if she'd hit him, she would have blown his brains out right next to the kids. So she's certainly not any innocent female defender in my view. That's got nothing to do with whether or not aggravated assault should be in 1020 life. I certainly agree that it ought not be, particularly given the way that it was abused by the prosecution. But here we have the husband, and how'd the husband get convicted? Well, the woman involved, of course, the wife is dead, but the woman who was seriously injured, the attempted murder victim, she would testify at trial about all kinds of mean stuff and threatening things that the husband had done. The other woman in the house had provided similar testimony. His own children, he actually had gotten his 15-year-old son to help him in the shooting. So the son went to the scene of the shooting with him, entered the house with him, tampered with evidence on his behalf at his instruction. And of course, the son would testify at trial against his father, against the husband. So there was plenty of facts here from which to find him guilty, as obviously the jury ultimately did. But here's the issue for us to discuss today, and that is that the Weiss did not like his attorney, and his attorney was a court-appointed public defender. I think he had two, actually. Yes.
The key is not necessarily public defender. The key is court appointed.
Right.
So you can have a conflict situation where you are appointed a lawyer for free, and the same law will apply as in this case.
So a lot of people seem to have the understanding or the belief that once they've hired a lawyer or a lawyer has been assigned to them, depending on the case, that they basically have like a legal butler who's there at their beck and call anytime they want, to answer any question they want, to do whatever they want. And that's just not how any of this works. There's often, occasional communication between the lawyer and the client. There's often less than complete explanation of the law or the evidence. The lawyer's job is not to train or educate the client. It's to represent the client. And you want some level of reasonable communication so if you have a reasonable relationship. But the legal standard for the lawyer is whether or not he's provided effective assistance to counsel. That's what you're constitutionally entitled to. And he may well have done that, typically does do that, even if the client's not particularly happy with the level of service that he's getting from that particular lawyer.
Well, actually, the legal standard, I did a little homework before this.
Oh, good for you.
And the legal standard is actually the Strickland standard, which you're probably familiar with, Strickland v. Washington, which is a United States Supreme Court case from 1984. And there's a two-part test for whether a lawyer is deficient. The first part is counsel is presumed competent and trial tactics are unchallengeable. So the first question is, was counsel deficient? And they're presumed competent. And then the second one was the defendant prejudiced? So it's, was he deficient and was the defendant prejudiced? That's the two-part Strickland test. So so there we go. That's the full test on Strickland. And I know that it's a U.S. Supreme Court case, so the same law in Florida is the same law as Montana on that issue.
And as long as you're getting this effective assistance to counsel, the law doesn't really care who the individual lawyer is. You don't have a constitutional right to a particular lawyer.
Right,
you have a constitutional right to a lawyer, to effective assistance to counsel. And here the court had assigned counsel, and this defendant was not happy with his lawyer, and he complained to the court about it. And the court looked, and the court actually, I mean, frankly, went beyond what they needed to do. They actually looked at whether or not he was being provided with effective assistance. It looks like they did a reasonably thorough job of that.
I'll chime in here too, because now I'm a Florida lawyer, so I look at this type of issue a lot in Florida. And what happens is in Florida, let me see here, it's called a Nelson hearing. Okay, and in Florida, if somebody alleges that they're unhappy with their lawyer and their lawyer is not providing competent representation, in Florida, the court must do an inquiry, and that's called a Nelson hearing. And if they fail to do that, that's error. So this is the type of thing that an appellate lawyer looks for, is did the client allege incompetent counsel? And if so, was there a hearing? If there's a hearing, then the court conducts a hearing with the lawyer and the defendant present. That's called a Nelson hearing in Florida, in which they do the two-part Strickland test. And they'll go back and forth from the client and the defense counsel and say, okay, well, what are your problems? And they'll say, well, he's not communicating with me. That's usually the complaint, because no defendant ever gets enough communication. And then the lawyer says, well, I visited him 4 times in the jail and I've given him his discovery and I've done this. And the lawyer is usually given the credibility over the defendant. Or after they get done explaining it, the guy says, well, I guess I'm happy with a lawyer. Let's just go forward and forget about it. But this is, and I'm not sure if Montana requires a hearing, but Florida does.
Yeah, so it certainly looks, whether they're required or not, it looks like the judge did something similar here. He actually asked questions and did a little investigation, and that decided, this would be the district court, the trial court decided, no, your lawyer's fine, your lawyer's fine, I'm not changing this. Because, by the way, you can imagine what it would be like for the trial court if he suddenly had to start reassigning new counsel to defendants who were complainers, squeaky wheels. And of course, every time you do that, the new lawyers would have to get up to speed, and then the client would be, especially if they're likely to be found guilty, they're not going to be happy with those lawyers either, and they'll want different lawyers. So there comes a point here where efficiency is going to be a dominating factor in the judge's mind, unless there's some clear showing that the counsel is actually somehow defective. And here, the district court decided counsel was not effective. So here's a bunch of the factors that the court looks at. These were the complaints, actually, by the client. So that lack of availability of counsel. So they seem to expect that the lawyer is going to be in the jail cell with them to talk to them like a buddy, like in a cop buddy movie. Failure to provide adversarial defense. I'm not even sure what he means there. Lies, misinformation, and gaslighting. He's accusing his lawyer of gaslighting of the defendant. Insults directed at the at the defendant by the lawyers. Hostility directed at the defendant by the one of the lawyers, and I guess they had an investigator. Retaliatory behavior after the defendant complained about the lawyers. Threats of retaliatory behavior after the complaint if he should continue seeking new counsel. Breach of confidentiality. Assistance to the state in prosecution. So he's saying his own lawyers were helping the state in his own.
Well, that's what a lot of our clients think, is that we are collaborating with the prosecutors because maybe we go out to lunch or we're buddies with them, but it's our job to get good deals. So oftentimes there's schmoozing going on, but that's for the benefit of the client. And actually, I'm one of those lawyers that I get very few complaints, but it's because I tend to be very adversarial and very aggressive in court. And when I'm that way, the clients love that because that's what they want to see you do. However, I would say that I'm not the best guy when you're trying to negotiate a plea deal. Because when you're trying to negotiate a plea deal, all I'm doing is making the prosecutors upset. And then they want to threaten me and bump their chest. That's why I usually assist the trial division and participate in trials where the war is on, right? As opposed to schmoozing the prosecutor. But that's a typical complaint, is he's schmoozing the prosecutor and I don't like it. They're teaming up against me. And it's understandable because, you know, this is just, it's like the patient and the doctor's talking about the patient at bedside, right?
And I think it may be a little bit different in the criminal and the civil context. So I think, you know, I cover these high profile cases, and I think often we'll see, especially on breaks during the proceedings, the defense counsel in a criminal case might be apparently sharing a joke with the prosecution, or there's a smile, or there's a bat pack or something. It doesn't mean they're on the same team, folks. But these are people who may see each other on a fairly regular basis. I mean, they're doing criminal work in the same area. It's probably not the first time they've met if they've been doing this for any period of time. They may expect, hey, I may have to meet this guy again. I may have to cut a deal for another client with this prosecutor. So I'm not just going to be a dick. When we watch those trials, we know we're never going to see those people again. And we may assume that they're never going to see each other again. And we want if we're favorable to the defendant, we want his lawyer to come across as a tiger, snarling all the time in defense of the guy who we favor. And when we don't see that, or we see contrary behavior, it seems odd to us, counterintuitive to us. What people seem to expect is much more along the lines of what was seen in the Johnny Depp Amber Heard civil trial, where the lawyers on each side clearly despised each other.
Well, and those lawyers are fighting for the money in their own mouths. So it becomes, it's a lot more personal in a civil context because it's high stakes. And if you're on a contingency, that's directly related to my paycheck. So lawyers get really nasty in civil, and it's hard for people to understand, but criminal law is a lot more congenial a practice than civil practice because of that. Because if you're in civil, I mean, when are those lawyers ever going to interact again? So it becomes very scorched earth, very dirty. Another point, I want to scroll up a little bit here on if your mouse is working.
Yep.
Because the A
Am I
point,
past it already, or am I getting to it?
go back the other way.
The other way. Okay.
He has a list. There it is. A, lack of availability of counsel. And, speaking from a public defender side, you have a routine and you're going and visiting the jail. There's times when you need client input. There's times when you're just working with the law and trying to figure things out. That's something that you get a lot better when you're paying for your lawyer, I would say, is better. One of the things you're paying for is more tea and sympathy or client attorney contact. So when you're talking about privately retained counsel, that's something that I think you can have a little bit more expectation. But when they're talking about that lawyer isn't coming, seeing me and giving me all this tea and sympathy, well, how much did you pay that lawyer again? Right? You paid him nothing. So this is state provided. So as a state employee, you're looking to triage your cases, you're putting it together, and you have a routine, and you're dealing with a lot of cases, maybe 100, maybe 200 cases. And so it's a lot less touchy-feely, and it's never sufficient for any client. They want you to be there every day writing. And like I have a statement when I'm training our lawyers. I say, we are not their pen pals, we're their lawyers. And so they can really abuse counsel on this A from a lawyer's perspective. But you get, I think with the private counsel, you're going to get a lot better attention. I mean, what is your perspective on that?
Yeah, I think so, if only for practical reasons. I mean, it's a common perception out in the public that if someone gets a public defender, they somehow got some kind of deficient legal representation. And I've never had that perception, because my first job in the law was working for a public defender's office. Now, I wasn't a lawyer at the time. I was actually hired as an investigator for the public defender's office. That was before I went to law school. But I saw those people work, and they were, and then and since, public defenders have been among the most capable lawyers I've ever worked with. So, in fact, a lot of them get vastly more trial time than you would expect, than you could anticipate or reasonably expect from a private practice attorney, who would get much less trial time. But I think often, people who are criminally charged, especially if they're looking at real time, they're panicked all the time. I mean, they're constantly thinking, it's like having a cancer diagnosis, right? Is this going to be the end of me? And every time they panic, they want to talk to the lawyer for reassurance, which, by the way, they may not get, because they may have a really shitty legal position. The lawyer may be telling them to hey, if they offer you a 10-year plea, we better take it, which nobody is really happy to hear unless you're looking at 220 years consecutive. Which is really bad.
Yeah, I've got so many real world anecdotes behind each one of these that it would be a little overwhelming. But I've seen private attorneys just abuse their clients in open court. And it drops my jaw, because I always try to be respectful for our clients, and I think respect is mutual. And if you don't give it, you're not going to get it. But I've seen some lawyers in town here who stand up and yell at their clients in open court. I've told him to plea, and this is a fair deal for my client, and he's an idiot. And I mean, serious, I'm not joking. In language saltier than that,
yeah,
in open court. Now, of course, it doesn't really impact the case because it's not in front of a jury, right? So if you go to a jury trial, that abuse is not going to be reflected. But what I've seen done in open court by private attorneys is unbelievable. So, and they, there's no problem with that. They're trying to convince their client to take a good deal, what they think is a good deal, and they hired him. Yeah. So I don't know. It's just a strange world, the practice of law.
So here we have the trial court here looked at the defendant's complaints and concluded that many of the defendant's complaints regarding counsel involve strategic and tactical decision-making or other aspects of their representation. So folks, there's lots of decisions a lawyer makes, things he could pursue, arguments he could make that he chooses not to, because it might be inconsistent with some other path or some other argument. You can't coherently argue both. He has to choose. And of course, if the client gets convicted, he always thinks the lawyer made the wrong choice, right? That's why he got convicted. So the defendant's always complaining. I mean, ineffective assistance of counsel is perhaps the most common grounds for an appeal ever, almost never effective, as appeals generally are never effective.
Well, I'll distinguish actually in direct appeals, and this is Florida. Again, I'm a Florida lawyer, but in direct appeals, ineffective assistance of counsel on the face of the record is pretty rare. But that's because in Florida, they try to push these kind of claims into post appeal, like what we call a 3850, which is under the rule 3850. And so after your direct appeal is over, which is a review of the law, then and the reason for that is because it has to be obvious from the face of the record that there is ineffective assistance of counsel. And I've argued that maybe 3 or 4 times. But usually what happens is the clients are bringing up stuff that's not in the record. He told me not to take the deal. He abused me. He didn't communicate. And these things, none of them are present in the appellate record. And that requires an evidentiary hearing after the appeal. In appeals, we don't have evidentiary hearings. We are stuck with the record as given. So
that's a great point, actually. That I mentioned from time to time, but normally an appellate court, for example, would not hear witnesses, would not get direct evidence. They're looking at whatever's in the record from the trial, and that's it. One of the rare exceptions to that is where there is an ineffective assistance of counsel claim, and then the appellate court may actually have the lawyer come in and explain what his rationale was for his decision-making, so they know whether or not it was 1, incompetence, ineffective assistance, or 2, simply tactical decision-making on the part of the attorney was reasonable for the attorney in the circumstances.
And also we get ineffective assistance of appellate counsel for not raising issues that we should have raised. So in fact, my nightmare is to write an Anders brief, which saying there's no issues in the case, and then have the client write a brief and then have them win on something that I missed. So I never had that happen. I have missed an issue. Well, I've missed it twice in my 12 years. I've missed issues that the court has caught and told me to brief and then going on to win. So that does happen, and that's pretty bad. But when we all make mistakes out of the hundreds of cases, but I've never had a client raise a winning point. So I can't say I'm that bad.
Okay, so here we have the defendant complaining to the trial court about his lawyer. The trial court's not buying it. You're stuck with the lawyers I gave you. The trial takes place. The state presents its witnesses, and the jury finds the defendant guilty of both counts. That's intentional murder and attempted intentional murder, and that he used a gun to commit the offenses. So that's the factual finding necessary for the gun sentencing enhancements. And the trial court, here. At the sentencing hearing, this is great stuff. So this is the guy who's been claiming his innocence the whole time. He blamed the charges on his mental health and argued, we're all victims, whether I'm guilty or not. He maintained his innocence, claiming he was lynched in the Montana tradition, and accused the trial court of buying his attorney's pizza for lunch during the trial.
Hey, good court.
The district court imposed a 100-year sentence to the Montana State Prison for each count. That's the murder and attempted murder counts to run consecutively 200 years, and imposed a 10-year consecutive weapon enhancement for each offense. That's another 20 years served consecutively, and he's ineligible for parole. And now the defendant appeals. And the grounds for his appeal here in this decision is that the trial court made an error in not accepting his argument that his lawyer should have been replaced. And now we get into the appellate arguments here about the U.S. Constitution, Montana Constitution guaranteeing criminal defendants the right to effective assistance of counsel, but it does not give you a right to grant a defendant the right to counsel of his or her choice. You get a lawyer. You don't get the lawyer that you might prefer. Any thoughts on what I just covered, Steve?
No, that's exactly right. I mean, of course, everybody knows the Gideon v. Wainwright, which established the right to a court-appointed lawyer, but then they're appointed, and the lawyer has as little choice as the defendant. I mean, from a public defendant, maybe I'll say a little secret. I'll whisper to just you if you don't tell anybody. Is that, I mean, there's a certain amount of emotional conflict that goes on when your client wants to kick you off the case, because I don't get paid by the case. I don't care if I represent this guy or not. In fact, I probably don't like him, right? But my job is to represent him to the best of my ability, and that which I do. Even the worst clients, I'll represent to the best of my ability. But sometimes I'm like, you know what, court? I agree with him. Kick me off the case. I'd be happy to be off the case. And and a lot of times that shakes up the clients, because they're like, well, why aren't you fighting to be on my case? It's because I don't need your case. I'm not getting paid by the case.
Right.
So
I mean, I've often said the worst part of practicing law is the clients.
Yeah. So it's like when they're jumping up and down, the lawyer is secretly rooting for him to get kicked off. He's like, yes, I'm ineffective. Kick me off.
Okay, so now the appellate court, I can't find the reference to this now in this decision. I don't want to go through every word, but basically the Montana Supreme Court is saying, hey, the appellate court made a decision on this, and we're not going to second guess their decision unless it's I believe they're applying an abuse of discretion standard, which is the decision by the trial court had to be so outside the bounds of reason that it's incontestable that they made a bad decision. If it's just a judgment call and a reasonable court could have gone either way, maybe if we were the trial court, we would have gone the other way. But we're not the trial court, and we don't want the trial court's job. They have a job. They're doing that job. As long as it's within the bounds of reasonable discretion, we're not going to second guess their decision. And what was presented here to the Montana Supreme Court did not exceed the bounds of reasonable discretion by the trial court. The Montana Supreme Court concluded. And so the ultimate conclusion here is they say, sorry, the district court, even if you think if I were in the district court's, the trial court's position, I would have made a different decision. It's up to them. That's their job to make that decision. It was not an unreasonable decision. And therefore we're going to affirm that decision.
This is something that, I mean, like I said, I review this on almost every case where this is one of those things that we look for in the record is, did the client ask for a Nelson hearing? Now, there's a couple other little fun things inside baseball that your chat room and your listeners might want to be interested in. One is, it's funny because public defenders and defense attorneys generally, we get abused from all sides, right? We're getting abused by the judges, by the prosecutors, by the clients, everybody, everybody, all the people in the media, all these people hate we assistant public defenders who are just out there trying to do our best, right? Except when the client wants to kick you off the case. When that happens, all of a sudden the judges talk about how great, this is the best counsel that we have, and the prosecutors, no, they're great. And the reason is because they don't want to deal with the pro se litigant. And you have an absolute right to represent yourself. So you can fire the public defender's office and represent yourself, which is a stupid idea, but you can do it, right? And if you do that, then the judges and the prosecutors have to deal with them directly. And the defense attorneys really make the machine work, for better or worse. It is a machine, and we participate in that machine, and we grease the wheels of that justice. So, it's funny how bad we are until the client wants to kick you off the case. Then everything turns around and says, "Oh no, he's
right."
Great. I love those things." So, yes, tell me how great.
We've all seen those cases where, in fact, there was a recent one in the news just in the last week or so, where the defendant actually gets to represent himself in court, and we see what a circus that quickly turns into. That is no joy at all.
Prosecutors hate it; they can't deal with that. And they don't appreciate that until you're done without it. Because the way I see it, it is a system. It's a criminal justice system. It's an adversarial system. And that adversarial system depends on three parts. That is the judge, who should be a fair arbiter of disputes, a prosecutor who should be an advocate for the truth.
For justice,
right? And the American way. And defense attorneys who are advocates for their client, zealous advocates for their client. Well, usually the defense attorneys are zealous advocates for client. That is usually the case. Usually the problems in the system is when one of the other two legs of that stool aren't functioning properly. Either the prosecutors are advocates for guilt, or hell at all high water, they want to find somebody guilty and cheat to get that way, or a judge who wants to put their finger on the scales of justice and say, well, I'm pro-prosecution, or even I'm pro-defense. They
just get pushed around.
What's that?
Or they get pushed around.
Yeah, right. Well, you've seen that. I remember that was the popcorn shooter case. That judge was weak and it was not predictable. The law should be predictable, and a judge should be predictable. A good judge should be predictable, but that's not the case. We're all human, and we all have our flaws. But anyway, so that's my 2 cents.
So what about the other side of the coin, Steve? What about when the lawyer wants to fire the client?
Well, this is the thing. As a public defender, this is one of the few jobs that you can't fire the client. I mean, I have to take that client and I have to represent them. And I do capital appeals, and I also assist the capital division. So that's first-degree murder charges where the penalty is death. And those cases are horrific and very hard to represent. And people say, how can you represent that? Well, the reason is because I believe in an adversarial system. we have a system of justice that requires all three components to be functioning properly in order to adjudicate some just outcome, right? So if you say, well, nobody's going to represent the defendant in a case like that, then you don't have an adversarial system. You know, it's like I am just as required as a defense attorney as is the prosecutor and as is the judge. We're all working within that system, within the bounds we have. Now, capital cases, those people need representation. They're entitled to representation, and somebody's got to do it. And I had a doctor friend of mine who asked me that very question. It's like, well, how can you represent this, you know, whatever media client that we're talking about at the latest brutal murder, right? I'm like, well, if he came in on a stretcher with a gunshot wound, would you refuse to treat him? I'm not participating in the murder. The client came to me with the gunshot wound, right? Or the cancer. The guy came to the doctor with cancer. You're trying to operate so the guy has some life left in him, or make the bad situation as good as you possibly can. And sometimes that's life in prison rather than death penalty.
Right. I mean, what I've seen in private practice is I have seen cases where, for example, the client stops paying the lawyer and the lawyer wants to dump the client and the judge won't allow it.
That happens in private practice all the time.
Yeah.
And in fact, we have
what you see in private practice is the defense lawyers, first of all, they get paid up front because they know if they don't get paid up front, they won't get anything, which is how you get these huge retainers, $50,000, $100,000. And they write the retainer agreements very, very carefully. So the scope of their work is very well defined and strictly limited to whatever the cash they've received as a retainer covers. And once that's done, once they've met their contractual obligations, then they have an argument to make to a judge that, listen, my relationship with this client is over. This is what I agreed to, and I did all that. And they knew from the beginning that if I was going to be the next step, we would have to have another agreement.
Well, and there's unethical lawyers, or maybe just lawyers who suck money out of people and then dump the client. And then I know a lot of the defense bar here, and some of them, they get the best lawyers that I know represent them on the second time around when they don't have any money left, and they're begging for new counsel because their privately retained lawyer dumped them and took all their money. So it's tough. I mean, and it's a hard, dealing with lawyers is difficult.
Okay, so I'm going to turn to the super chats. It doesn't look like we have all that much.
I think there were some internet issues going on in the chat room. I was looking at Shane's
comment, okay,
and he said that there's some kind of issues there.
Okay,
well, I might have another. Actually, I have a question for you. Can I ask?
Sure.
Super chat. I want to hear you. You said this morning that you had studied with Jeff Cooper.
Jeff Cooper, yeah. Long time ago. I have a certificate up on the wall behind me. Let's see.
Yeah, Jeff Cooper is pretty cool.
The bottom one here, behind that big brass shell casing I have there.
Yeah, Jeff Cooper is the writer, wrote The Art of the Rifle and was involved in the war in Rhodesia at the time, and has a very, he developed, I think, the system of, what is it? The coding system, green, yellow, red, black.
Yep.
And very interesting. He has very strong opinions about, in fact, I agree with his opinion on scope placement on rifles, right? Eye relief scope placement. All these people, they like to put the scope right up to their eye, and then they get rings around their eye when it kicks and it kills them. Whereas he provides a large scope distance so that you can have situational awareness and still use your scope. So he mounts the scope further out on the end of the rifle.
Yeah, and if anyone has never tried that, it's a life-changing experience. When you bring that rifle up and you still get either the crosshairs or the dot, whatever you're using, and you can see completely around the perimeter of the scope. You can see everything else that's going on. It's just a fantastic. It's called the Scout style of
Scout rifle, right?
Yeah,
I think that there was M1A1 Garands that were, or that's the M1A. I think there's a rifle that was designed off of his thoughts and his opinions. I'm not completely bought in. I mean, I think it's a long. I mean, when did he pass away? I mean, he's been around.
Oh, I mean, gosh, it had to be within 5 or 6 or 7 years after I took his course. So that was right around 2000, early 2000s, probably.
Right. So, I mean, I think the technology has moved forward, but a lot of his concepts were really thoughtful and thought through. I'm not a big Bolty fan, although, he's a bolt action guy. But anyways, that was my question.
He died
in super chat.
He died in 2006. So that was about 10 years after I took the course with him. Yeah, he was an interesting guy. Changed the way people fight with pistols for sure.
Another question I had for you is that that this case doesn't quite cover, but you see a lot of times, is last-minute counsel substitutions and pro se litigants. Those are the two issues that are surround this. And a lot of times, once you get locked in, like we're ready for trial, even a privately retained lawyer can be ordered to represent somebody. They won't let the trial, at least in Florida, I've seen it where private counsel, like all of a sudden, I didn't anticipate this being a trial, and it's a week before trial, and they try to get out because, well, I wasn't paid. Sometimes the court will say, I don't care, you're in, because because we only got a week to go, and your pocketbook doesn't matter.
Yeah, man, I've seen cases where the local public defender's office is just completely understaffed, and the judge gets frustrated and just starts picking lawyers off the bar list and assigning them to represent clients, and you have to do it.
And then the one other issue is that the pro se litigant, which is pro se means representing yourself, and you have an absolute right to represent yourself. And there are certain critical times that you must be consulted. For example, when you decide to take the stand on a trial or not, that requires defendant counseled advice. So the judge will get off and say, let me talk to the defendant directly.
Right.
So, and whenever you concede an element of guilt is another one. So sometimes you may have a defense, and the defense may say, well, we're not arguing about element 1 or 2. We're only arguing about element 3. In order to concede that, you really need permission of your client, because a lawyer can't plea first. Another one is a lawyer can't plea for their client. And I've had that. I've had lawyers pleading for their clients because they do all the talking and it's a plea. And so they do the same thing and the client never says anything. Right. And so anyway, just some other wrinkles. And there's so many ways that this can be turned in so many cases, but it's fascinating.
So I'll turn to the super chats. Folks, don't remember, before I do that, if that subscribe button on your YouTube screen is red, please smash it until it turns gray. It may take a few hits. Just keep hitting it until it turns gray. Hit that bell. Make sure you get notifications. Hit that thumbs like up. Hit that thumbs up button. I say this enough, you'd think I'd get it right. But and if you could just leave a comment in the chat, even if it's just your city and state, that helps fool the algorithm in terms of apparent engagement, and spreads our contact more broadly. So, but the big number for us is subscribers, folks. The more subscribers you have, the more YouTube thinks that you're popular, naturally enough, and the more they spread your content. The mission of YouTube is to distribute content that gets the most eyeballs for the longest. That's what they're looking for. So to the extent we can exploit that inherent desire by the YouTube algorithm, the more effectively we can get our content and message out. And the biggest thing you can do to help that is subscribe, tell your friends to subscribe, all that kind of stuff. All right, so we have a super chat here from Switch 1947, $40. I have to get a ka-ching sound effect here. Thank you very much, Switch 1947. And not only that, he didn't even ask a question there, but he gave another super chat, $10, another $10. And he says, platinum member, I guess he's a platinum member, can a defendant, that would be a platinum member of Law of Self-Defense, folks. So the only, effective this year, the only cases on which we do legal consults moving forward is for our platinum members. If you're not a platinum member, folks, I get letters every week. I thought I had a recent one here on my desk. I must have filed it already. I get letters every week from people asking us to consult on their cases, but there's too many. So unless someone's a platinum member, they do not get a legal consult from us at any price. And if you are a platinum member, you get that legal consult for free. I mean, before this year, we were charging a minimum of $10,000 to consult on a case. So we don't take non-platinum cases anymore. When we take a platinum case, we cover you for free. It's part of your membership. If you'd like to learn more about that, lawofselfdefense.com/platinum. If you'd like to make sure I'm available to consult on your case if you're involved in an event. Otherwise, you're going to call and we're going to say sorry.
And I'd just like to say thank you to the taxpayers of Florida for paying my salary. So that's about all I got for remote.
All right. Switch 1947, platinum member. Can a defendant demand a separate trial in Arbery? Could or should the neighbor have asked for a separate trial? So the Ahmaud Arbery case, you had all three men being tried at the same time. And that's kind of normally the case when, I mean, essentially the facts are the same facts for everyone involved. you're not. It's not like you're going to have vastly different witnesses or vastly different testimony or vastly different law applying.
Well,
Any defendant, of course, would prefer they be tried on their own merits. But what are your thoughts on this, Steve?
well, that's called a Bruton request. Hold on a second. I'm going to look it up, just make sure I get it right here. A Bruton request is, U.S. 1968 Bruton v. U.S. And that is, a lot of that is whether you're entitled to a separate trial as a defendant from other co-defendants. It depends if there are statements made by co-defendants that have to be heard. So, for example, if somebody on your co-defendant is accusing you or blaming you, or there's a conflict like that, you have to be very careful as a court trying people together for conflicts between defendants. Now, if they're all in agreement as to the defense or the facts, then there's no Bruton issue. But if there's a confrontation clause, like differing interests of differing parties that affects the rights of different parties, then it's really tricky, and they must separate under Bruton v. U.S. And that's another issue. Whenever I see a co-defendant case, I look at in appeals is whether or not you have co-defendants. Immediately I say, is there a Bruton issue? And then you have to just look at it and see, are there it has to be preserved properly by trial counsel, which is very hard. I really believe that they put too much on defense attorneys for preservation, because it's this artificial way for them not to decide things.
Right.
And no attorney is so good that they can catch everything. And it's kind of a gotcha, ha moment, like, well, you waived it because your attorney didn't bring it up. They didn't waive anything. Their attorney missed it, or was busy doing other stuff, or was, focused on winning the trial, not losing. Right. So I really, and that's another article one of these days, it's in the back of the head that I need to write about, is about the ridiculous preservation standards in appeals. However, going back to the question, which was your Super Chat Platinum member, is that look up Bruton v. U.S., Bruton, that talks about when a separate severance of clients was required. And I imagine that kind of case, that's going to be looked at, and they probably had the same interest, right? I mean, there wasn't a confession of one and not the others, right? Yeah.
In fact, I mean, the defense was the same for all of them, that basically nothing unlawful happened. What happened was not outside the bounds of the law. And frankly, I presume the defense attorneys decided, hey, this is going to be a more compelling defense if we're all making the same statement at the same time together, coherently. It could have gone differently, especially for the neighbor. You had the father and son who were in the truck with the guns. The neighbor didn't have a gun, and he was in his own vehicle, so he could have gone a different way, but I guess they decided ultimately not to do that. So when Steve talks about preservation, folks, if you want to be successful on appeal on some issue, first, whatever you're claiming was wrong, you have to have preserved it at trial, normally by an objection. Also, the court to which you're appealing has to agree that it was actually an error. So that's 2. And then 3, they have to agree that even if the error occurred and it was preserved, that it mattered, that there might have been a different outcome.
Well, that's actually the second Strickland prong, which we're talking about in this case, was defendant prejudiced? Right. So even if you had deficient counsel, if it was on an issue that didn't matter, they're going to say it was harmless, and they're going to affirm. So, and we lose a lot on that. Of course, it's hard to say, but there's a million ways to lose an appeal. In fact, a lot of times, like I said, when I help out trial counsel, a trial division, sometimes what I'll do is I'll just sit second chair and just be the objector, be the guy who's preservation. And when there's an issue that may be appealable, I'll poke him and say, hey, you need to do X, Y, and Z, or ask this. Get a ruling out of the court, because sometimes courts will sit back and this is, if you're pro se, you'll never catch this, but you make an objection and the court will go, interesting issue. Move on, counselor. They never ruled. Right. And unless you get a ruling from the court, there's nothing to appeal. Yep. And it sounds like a stupid thing, but judges are wily characters, right? And they know those little tricks. I know a couple judges right off the bat that I've practiced in front of that would play those kind of games. They wouldn't rule. And so you really have to nail them down. And I mean, I remember, and like I said, I know how to win friends and influence people in the courtroom. I remember one time I had a judge who wouldn't rule on my motion. And I sat there for like 90 seconds in silence as he just sat there and stared at me and didn't say anything. So I said, well, I'm assuming since we've been 90 seconds on the clock and you haven't said anything that you're overruled. And he says, you'll assume no this thing, counselor. And
Right.
so,
Well, trial judges, they if there's anything they hate in the world, it's getting reversed on appeal. So if they can go about their day and not provide the building blocks that would be necessary for a reversal, that's all in their favor.
exactly. Right.
All right, folks, let's see if there's anything else. It looks, let me do a quick refresh here just to make sure I don't miss anybody. Folks, I do know I see a super chat here letting me know there's some kind of problem with streaming on the law self-defense page. I'm gonna have one of our people look at it. That's nothing I can fix on the fly. Trust me, I'm a caveman when it comes to this stuff. I apologize for that. We do the best we can.
Can I promote something else?
Yeah, of course, Steve. Go ahead.
Well, I actually asked my big boss, the elected public defender, Matt Metz is our elected public defender, about participating in these things. He's like, as long as it doesn't interfere with your work, it's great, right? But one thing, we have a great office, and you've met at least 3 of our great lawyers, Rosemary Peoples and John Terhune.
Yep.
And we're a great training ground. And your chat room, and a lot of your listeners are potential, maybe they're going to be criminal defense lawyers. Daytona Beach, Florida, St. Augustine, Florida is not a bad place to live. And we have a great office that has a very good training program. So, and we're always looking for people who really want to learn the law and be good lawyers. And we want the best lawyers. So, if you are a potential 3rd-year law student or want to get into practice of law, think about coming to Florida, coming to Daytona Beach and practicing in the 7th Circuit.
Well, I will say the members of the law self-defense community I probably have the most and closest interaction with are the folks who go through our law self-defense instructor program. And we've had a number of those people go through our instructor program, which is really intended to be a place where self-defense instructors, existing successful self-defense instructors can get something like a law school seminar education on self-defense law. And we've had a number of those guys go through that instructor program and then decide to go to law school and actually go through law school, pass the bar, and now they're practicing attorneys. So always gratifying to see people pursue that kind of path. So yeah, maybe we're creating new capable.
Bring them on. Tell them to contact our office. We have a great train, and it's hard to find that in law, as you well know. I mean, where are you going to get that big firm or private practice in your own, hanging out your shingle? I mean, where do you get experience? And especially with a team, we have a really good team that's been built over a long period of time with some really excellent lawyers. And I'm just proud to be in our office and around the expertise that we have. And I learn, they learn, and we really do tackle things in a way here. It's a great way to practice I'm very happy where I am. So I'm just throwing that out. I don't know. Maybe there's a 1st-year law student out there who says, that's something I hadn't considered, but getting that training might be exactly what I need to be.
I mean, if people like trial work, I can't imagine a better place than the public defender's office. I mean, I guess, prosecutors but it's different. I think it's a harder game for the defense than it is for the state.
Well, I think we really practice law, and a lot of the prosecutor stuff, it's a different thing, but it's a little bit more paint by numbers. It's like you got your cops doing the job. You call them, you've got your 4 elements. The cops come in, you say, okay, what about this? What about tell your story? You tell the story, you kind of mail it in. With being a defense attorney, you really have to get into the weeds of whether the defense is anticipating what the other side's going to do, seeing both sides, seeing where the edges are, understanding juries. It's a lot. I'd say it's kind of like the real lawyering part. Now, if you're doing prosecution right, then it's very difficult. But you can also be very sloppy and very paint by numbers and not really learn how to be a great lawyer, especially if your office doesn't offer the training like our office does. If you just have an office that plugs holes and throws you in the battle line, that's not learning, that's just doing. And you can learn a lot of bad habits by not having good mentoring.
Yeah. I think it's easy to get lazy kind of from a legal perspective, legal practice perspective. All right, Steve, I don't want to keep you too much longer. We're a bit over an hour, and I see my wife is pacing outside my office door, so she must want me for some
late super chat, though. Do you want to do the late super chat?
Oh yeah, let me see what we got. Oops. Looks like I only see one more. Fritz. $20 super chat. Thank you very much, Fritz. Andrew's products and classes may save you from yourself. Consider the book and additional classes. I concur. You should consider all things law of self-defense at lawofselfdefense.com for sure. And if you're just curious, if you're law of self-defense curious, you can check us out on our free webinar, Hard to Convict, at hardtoconvict.com. Doesn't cost a penny, but you do have to sign up because there are limited seats available. So lock in your seat right now. There's a whole bunch of dates you can choose from at hardtoconvict.com. Steve, thank you as always again for coming on. I look forward to our lunch coming up soon. And I will say adieu to everybody just by reminding all of you, of course, that as always, if you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. And with that said, until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.